Mr. Rolfe, if you'll take yourself off of mute. If somebody's volume is up very high, that has their microphone on, there we go. Mr. Rolfe, is your volume up real high?
1 second. Is that better, Your Honor?
Much better, thank you. So, Mr. Rolfe, I'm Sterling Eves. I'm the chair of this panel today.
Hang on, he can't hear, Your Honor. Hang on.
I think that was what we were getting. Reverberation. There's the volume button on this.
See if that works. Can we try it?
Can we try
again?
We're back to echoing.
It sounds like you can't do it with two apparatuses in the same room. You have to, if you're all in the same room, the two are going to feed off each other.
All right.
I think we're okay now if you want to test.
All right.
Okay.
So, Mr. Rolfe, do you have any objection to taking an oath or an affirmation?
No, ma'am, I do not.
Would you raise your right hand? Do you solemnly swear or affirm that the evidence you will give before this hearing will be the truth and nothing but the truth?
I swear.
Thank you, sir. You put your hand down. If you would, please, for the record, tell us your name and spell it.
Garrett Rolfe, Garrettrolfe.
All right. And Mr. LaRusso, you are there with him, and Ms. Lawrence Hardy is going to ask him some questions. And so you're there to help your client through this, correct?
That is correct.
All right. Ms. Lawrence Hardy, your witness.
Mr. Rolfe, you intend to invoke the Fifth Amendment as a response to any question I ask about the events of June 12, 2020, and the shooting of Rayshard Brooks, and about the process which led to your dismissal from the Atlanta Police Department effective June 14, 2020. Is that correct?
Yes, ma'am, that's correct.
I don't believe that's what I set out. And I believe there are questions pertaining to the notice of proposed adverse action, the opportunity to appear, that probably would be answered.
Okay, I'll just go through my outline then. You can invoke the Fifth where you like or not. Mr. Rolfe, you shot 3 bullets at Rayshard Brooks while he was running away from you and struck him twice, killing him. Is that correct?
I wish to assert my rights under the Fifth Amendment of the United States Constitution, the Georgia Constitution, and state law, and I will not answer that question.
And at the time you shot Rayshard Brooks, the Taser 7 he was holding had already been deployed twice and had no more cartridges that could have caused harm. Is that correct?
I wish to assert my rights under the Fifth Amendment of the United States Constitution, the Georgia Constitution, and state law, and I will not answer that question.
You authorized the You authorized the IBPO, Lieutenant Allen, to accept and sign your NPAA and NFAA on your behalf, and to appear at your employee response session regarding your termination, correct?
I do not recall giving anyone authorization to appear for me or give any response on my behalf.
Did you have any conversations with Ken Allen regarding the incidents of June 12th, 2020?
Regarding the incident itself or regarding the hearing?
Regarding any of it?
Yes, I did.
Okay, please tell me what occurred in those conversations.
I wish to assert my rights under the Fifth Amendment of the United States Constitution, the Georgia Constitution, and state law, and I won't answer that question.
Okay, Mr. LaRusso, I'm confused. So I tried to listen very carefully when you outlined what he would and wouldn't testify to. I was actually quite surprised when he did testify, gave a substantive answer about the paperwork. Sounds like there's parts of that he will testify to and not. I just want to be mindful of the board's time. Can you specify what the contours are?
Well,
What the testimony will be so that we can just streamline it? I mean, I've got.
Well, let me get in here. Ms. Lawrence Hardy, I understood what the parameters are. At this point, my understanding, and correct me if I'm wrong, Attorney LaRusso, if it's about his background or his experience, that's fine to ask, he will answer. If it's about anything else, he's been given the advice to assert his Fifth Amendment rights. So
the only
background, y'all, if everyone will be, hold on just a moment. So, you know, you are running out of time, Ms. Lawrence Hardy, as you know. Ms. LaRusso has some left. He could call his client on direct if he wanted to and get the background information. So that's what I want to say. Ms. LaRusso, do you want to respond to Ms. Lawrence Hardy on her confusion about your client testifying?
It's a difficult thing to respond to. I think her questions are overly broad and conflating two different issues, and I think that's the concern. But I do intend to put some information on direct, and if I could suggest that, maybe if I do that, there will be the information will come out that's necessary without trampling on the areas that we've said are off limits.
And of course, Ms. Lawrence Hardy, you'd have an opportunity to cross-examine him at that point.
Well, and Madam Chair, I certainly can rely on your description of he will only testify as to background and experience. I don't have any questions about his background and experience.
Okay, so then you are through with this witness?
If that's all he's going to testify to, but just a moment ago, he testified to something he discussed with Ken Allen or did not discuss. So I just want to make sure that I'm agreeing to the contours of, I have no questions on background and experience. That I agree with.
Last word, Mr. LaRusso. On this point.
I have nothing else to add to that. I think that there's a way for us to move forward without running afoul of this issue.
All right. So at this point, Ms. Lawrence Hardy, you said you have no further questions. Does the city rest, or do you have another witness?
The city rests.
Now, hang on to that thought just a minute before you put a period on it. Are there any of the exhibits that you've mentioned and talked about and had witnesses testify to that need to be entered into the record that were not stipulated?
If so,
now I need for y'all to go back and look.
I would move to enter any exhibits that we have shown that are not currently in the record.
Did we put up anything that wasn't stipulated?
Our people are both checking.
I have just, for conversation, C1, C2. There are some procedures, of course, in here that you had. C31, C4, C19 and 20 were already were agreed to, and then that was it. That's all I had. So, Mr. LaRusso, question to you. Is there anything that you're aware of that you would object to that the city discussed with its witnesses?
No, Your Honor, just very briefly, I think everything that we've talked about except for 18 and 19, which are board documents, and Allegra, I'm trying to shorten this too for both of us, and I believe Exhibit 21, which is our demonstrative, I think other than that, everything's been stipulated to. I think we worked hard to try to get those stipulations to save time.
Okay.
Are there any ordinances that we've mentioned, Your Honor, that you believe were not into evidence? That's I believe they all were.
I believe they were too. Ms. Lawrence Hardy?
We just want to make sure that C21 and C31 are both in evidence. We have them up with Sergeant Dean.
Okay. C21 and 31, Mr. LaRusso, did you have any objection to those?
Let me figure out which ones they are, please. C21, are you talking about the videos? Are those the videos, Allegra?
Yes.
No, I mean, I don't think I don't think they really had any relevance to whether or not he was terminated properly, but I mean, they've been played before the board, so objecting at this point is a little late.
All right, so they'll be in for the record. So at this point then, city rests, Mr. LaRusso, it's your case. Mr. Elamine, he has, by my math, 10 minutes in round numbers.
Well, well, to sort of the dilemma, Judge, that we're going to go over for Mr. Russo to have the same time that Ms. Lawrence Hardy had. He actually has 26 minutes.
Okay,
So-
but he's going to be mindful to shorten it up. I know he will.
Right, and then they both have closings.
Right. Thank you, sir.
And Your Honor, can I inquire, could you tell me again, and I understand it's not a hard stop and y'all have been very pleasant about this, but what is your general hard stop for the board so they can have a break before the next hearing?
People have to be able to eat between hearings. So I would tell you that the hard stop is about 1:15, at the very latest about 1:25, and that's for everything both of y'all are going to say. Can you live with that?
We have been
And I
so
guess even
admonished.
if you can't, that's it.
We have been so admonished.
All right. So, Ms. LaRusso, proceed.
Are y'all able to hear us?
Yes. Yes.
Are you able to hear us? Okay, can we get a sound test so we can make sure we can hear you?
And we can hear you very well. Can you hear us? Can you hear me?
I can hear you just fine.
I think the appellant is having trouble hearing us. Mr. LaRusso, can you hear me?
I can hear you.
Okay.
How's that? Okay.
That's
Officer
good.
Rolfe,
Mr. Hawkins, you're all right?
I'm good.
Okay. Go ahead, Mr. LaRusso.
thank you. Officer Rolfe, can you tell us at what age you entered the Atlanta Police Academy?
I was 20 years old.
And why didn't you go to college? Why did you go to the police academy instead?
I was actually in college when I got hired by the Atlanta Police Department, but I knew from a very young age that being a police officer is what I wanted to do.
And how did you succeed in the police academy?
I graduated top of my class as valedictorian.
And how many people were in your class?
I believe we started with 53,
And how many finished?
26.
Now, when you graduated as valedictorian in the traditions of the City of Atlanta Police Department, does that give you a right to choose your zone?
It does.
And you chose Zone 3?
Yes, I did.
And can you tell us the general boundaries of Zone 3 for the purposes of the board?
Southeast Atlanta, south of I-20, encompassing neighborhoods such as Lakewood Heights, Mechanicsville, Pittsburgh, down to Cleveland Avenue, and to the termination point of the southeast ends of the city.
At some point, were you selected for Drug Recognition Expert School?
I was.
And can you tell the board how long that school is?
It's 160 hours. It takes approximately 1 month.
And is it recognized as a very strenuous academic course?
It is.
One of the most strenuous in law enforcement, would you agree?
That's what they say.
And how did you do?
I was the class valedictorian.
Why did you want to focus your work with the police department on DUI detection?
I saw that there was a great need for it. Many officers weren't familiar with the proper way to conduct DUI investigations. And in my time in Zone 3, I saw the damage and carnage that DUI drivers could cause.
Did you receive an award from the Mothers Against Drunk Driving in 2019?
I did.
And what award was that?
It was the silver pin for making more than 50 arrests.
At the time of June 12th, 2020, were you working through the Atlanta Police Foundation to try to buy a house in Zone 3?
Yes, I was.
And can you tell us why you chose Zone 3 as a place that you'd want to live?
I believe that it's important for officers to be members of the community that they're policing. I had worked in that area for many years. I had grown to know members of the community and the officers that worked it.
Now, it's been stipulated that you were familiar with Work Rule 4.2.50 prior to June 12th, 2020. Did you violate Work Rule 4.2.50 on June 12th, 2020?
No, I did not.
Tell the board how you first found out that the notice of proposed adverse action had been prepared and that your termination was contemplated.
I received a phone call.
And what time did you receive that phone call?
Approximately 3:45 p.m.
On the 13th of June?
Yes.
And I'm going to try to save time not putting it up for the board, but the NPAA lists a response deadline of 4:45 p.m., does it not?
I had never seen it prior to this point, but yes.
But you've heard that testimony that basically at 4:45 p.m. was the deadline on June 13th for you to respond.
I have heard that testimony, yeah.
And how long had you been up when you received that phone call on June 13th, 2020?
For more than 25 hours at that point.
How far away were you from downtown Atlanta and police headquarters at the time you were notified of the call?
I was more than an hour away by car.
Were you able to drive yourself at that point due to the fatigue?
No.
Did you have an opportunity to appear for the employee response session on June 13th, 2020?
No, I did not.
Did you want to appear to give an employee response session?
Yes, I did.
Fura leave has been discussed. Is Fura leave without pay?
No, it's not.
Do you understand it to just be an assignment?
Yes, it's an administrative assignment.
Are you personally aware of the time that passed between the presentation of the notice of proposed adverse action and the notice of final adverse action?
No, I'm not.
And the time that you were on Fura leave, were you permitted to be that far away from the center of the city?
Yes, I was.
Were you aware at that time that your face had been released, if not your name, but the video had been released to the media?
Yes, I was aware.
On June 13th, 2020 at 3:45 p.m., when you received a call, the first notice about the notice of proposed adverse action, did you believe it was safe for you to travel to the city of Atlanta to meet with anyone to provide an employee response session?
No, it was not safe.
Excuse me, I would like to object and move to strike all the previous testimony that does not go to background or experience. He doesn't get to pick and choose. If he's asserting his Fifth Amendment rights on the details of June 12th and the personnel actions that follow, then that's the Fifth Amendment right. It doesn't work this way where you get to assert some piece of it and then not assert it because your lawyer is the one asking the question. I believe the Fifth Amendment rights are being waived. And I
can respond.
I'd like Mr.
Please.
First of all, it does work that way. Second, all the questions I've asked are about June 13th, 2020, not June 12th, 2020. I have not asked a single question of this witness about June 12th, 2020, nor have I asked a single question about the events that led to the use of force. In addition, so far as the issue of the discipline, I have specifically stated at the outset that he would answer questions about his background or about his questions, which are the focus of this committee's hearing, whether or not once adverse action was proposed, whether it was done properly. That is the exact statement that I made when I said he would invoke the Fifth Amendment and the privilege regarding anything to do with the acts that occurred on June 12th, 2020.
I think the record is very clear and we move to strike. The chairman said very clearly background and experience, because that is what we heard you specify. You asked him whether he violated a work rule. That does not go to June 13th. So I move to strike.
Ms. LaRusso, I'm afraid she's right. Because you
Your
did
Honor,
ask a question about, sir, you did ask a question about the 12th and about a work rule. And so if he's asserting his right, he's asserting his right. And I believe Ms. Lawrence Hardy is correct on this point.
But he is able to select exactly what he wants to assert the fifth on. That is black letter law in Georgia. I can give the court the cites. That is absolutely permissible in a criminal case or an administrative case or a civil case. I can give the court the cites right now.
Okay, but here's what I heard that I think runs afoul of him asserting the fifth. There was a question, and we asked Ms. Fulgham to go back and read it for us, but there was a question about, did he violate any work rule with his actions on the 12th or something to that effect? Is that what you're talking about, Ms. Lawrence Hardy?
Yes, it is.
And so
Well, we heard the objection.
That was in, go ahead.
The objection, Your Honor, was that he was talking about more than background, and I specifically stated we would be talking about more than background. I set that at the outset, that he would talk about the discipline and that he would talk about his background and his employment, but nothing about the actual facts of what occurred. And he does get to pick and choose what he will assert the fifth on. It is for this board to decide whether it should be construed against him or what weight to carry with it. But he absolutely gets to choose which questions he asserts on. That is black letter law in Georgia. And I have the cites right here.
All right. But to the extent that you've asked him a question about violating a work rule on the 12th, you understand that Ms. Lawrence Hardy has a right to cross-examine him on that, right? Now that that's been introduced.
Or you can strike that answer, but if she cross-examines him on it, he has the right to plead the fifth. And if the court wants to strike that question and that answer, then that's appropriate. But the rest of the questions I asked had no difference. There's no differing whatsoever with what I said at the outset. And that's what my concern was with Ms. Lawrence Hardy's questions. They were too broad. They were not sticking to his background or to the issues with the discipline. That was my concern at the outset.
Ms. Lawrence Hardy?
Under the law of Georgia, if a witness invokes the fifth, but then goes on to selectively answer questions about the same subject matter, the court can determine there's been a waiver. And I am so mindful of the time and of the complicated legal issues. I don't know if it's, and of the important constitutional issues here. I don't know if you'd like us to brief this or how you'd like to proceed.
No, because as I said earlier, we don't have the authority to determine constitutional issues. I'm going to leave it right where it is. Mr. LaRusso, do you want to go forward asking your client questions? Ms. Lawrence Hardy's objection is on the record.
There are no further questions, and I was done at that point when the objection came.
How wonderful. Ms. Lawrence Hardy, do you have any cross questions?
I do. I have many now that we're talking about June the 12th. So I go back. Mr. Rolfe, you shot 3 bullets at Rayshard Brooks while he was running away from you on June the 12th and struck him twice, killing him. Is that correct?
Asked and answered. He's already asserted the privilege on that specific question.
I agree, Ms. Lawrence Hardy. What's your next question?
My question is, when you killed Mr. Rayshard Brooks, did you violate a work rule?
I wish to assert my rights under the Fifth Amendment to the United States Constitution, the Georgia Constitution, and state laws, and I won't answer that question.
And at this time, I move to strike all the testimony of Mr. Rolfe, and I move to dismiss his case pursuant to Savannah Associates versus Nashville and Gerala versus Pickett Street Hotel. He is the appellant, and it's one thing to plead the fifth, it's quite another to selectively plead it and answer some questions and not be willing to subject that same testimony to prosecution.
Mr. LaRusso?
Begner versus State Ethics Commission, 250 Georgia Appeals, 327, 2001. In addition, we have other case law Dempsey versus Kaminsky Jewelry, 278 Georgia Appeals, 8/14/2006. Hoffman versus U.S., 341 U.S. 479, 1951. A witness can selectively assert the fifth, and the body can decide whether or not a presumption would be against them. This is not a criminal case. If it was a criminal case, there would be a different standard. And so far as striking, if answers are to be struck in any fairness, it would be questions about the 12th if the court believes that I was treading over that boundary. The rest of his testimony had absolutely nothing to do with the 12th at all. It was related to the 13th, and it was related to the matters that specifically deal with the purview of this board. As you have said, the purview of this board does not extend to anything other than once an adverse action was contemplated, were the rules followed?
So at this point, ladies and gentlemen, we have run far afield of trying to get the appellant's case in. I understand your objections. Ms. Lawrence Hardy, if you have a question to ask of Mr. Rolfe on cross, please do so. You both understand I can't rule on these legal matters. This board is an administrative body. We are only here about the adverse employment action. And so at this point, Ms. Lawrence Hardy, do you have any other questions of Mr. Rolfe?
Mr. Rolfe, do you intend to invoke the Fifth Amendment after everything that's happened here today as a response to any question I ask about the events of June 12th, about the shooting of Rayshard Brooks, and about the process which led to your dismissal from the Atlanta Police Department effective June 14th?
Yes to all, except for the process that led to my dismissal.
So earlier when you told me you would assert the Fifth to that, that was incorrect.
I think that misrepresents his testimony, but we'd have to go back and look at it. I don't have time to do that. I just like the record.
Ms. Lawrence Hardy, what questions do you have of him?
You know, I'm going to, at this point, given I presume that I have about 3 minutes left, I'll save it for later.
All right. So anything, we're through with Mr. Rolfe, correct?
I just want to make, it sounds like it's denied. I just want to make sure I have a clean record that I have moved to strike and I've moved to dismiss.
I am not ruling on any of that. I don't have the authority to rule